1(1)(h), Roman numeral 2 of the Constitution, and held that the proceedings envisaged in Section 194 of the Constitution are a matter of common interest between the legislature and the executive. The High Court reasoned that the Speaker, as a representative and leader of the National Assembly, is obliged to inform the President when the Section 194 proceedings begins proceedings, and was, in this case, obliged to inform the President of the decision of the Section 194 Committee to resume its proceedings in line with what the previous Speaker did in similar circumstances. And the High Court held that by resuming the Section 194 inquiry, the committee did not infringe the sub judice rule or Rule 89 of the National Assembly rules as condemned by the Public Protector. In its view, the Section 194 committee would not be reflecting on the substantive strengths and weaknesses of the Public Protector's rescission application or the challenge to the constitutionality of the rules. Instead, the committee would be considering whether the Public Protector committed misconduct or is incompetent for any of the reasons alleged in the motion for her removal. The court reiterated that the sub judice rule does not preclude members of the National Assembly from carrying out their oversight functions and holding Chapter 9 institutions accountable. In respect of the President's decision to suspend the Public Protector, the High Court considered the line of events leading up to the suspension of the Public Protector, and that on 9 June 2022, the President suspended the Public Protector 2 days after she informed him that she was investigating him in respect of the Phala incident. According to the court, this constituted objective facts that found a basis to form a reasonable perception that the Public Protector's suspension was triggered by her decision to investigate the President. The High Court found no other plausible explanation for what it viewed as a premature suspension of the Public Protector. On 9 September 2022, the High Court declared the President's decision to suspend the Public Protector invalid, set aside the suspension effective from the date of its order, and ordered each party to pay its own costs. The Public Protector then unsuccessfully approached the full court in terms of Section 18 of the Superior Courts Act to render the judgment of the High Court operational and executable, pending any application for leave to appeal or appeal delivered in respect thereof. The full court held that the Constitutional Court had to make a final determination whether the conduct of the President was unconstitutional, and the order of the High Court had to be confirmed by the Constitutional Court before it had any effect. In the full court's view, irrespective of the wording used in the High Court's order, the judgment had no independent existence and was conditional upon confirmation by the Constitutional Court. Therefore, on a purely textual basis, Section 18 of the Superior Courts Act did not apply because it contemplates a binding decision, and a decision that is subject to confirmation by the Constitutional Court has no power. In this court, the DA submitted that the suspension of the Public Protector in the current circumstances was necessary to protect the integrity of the office of the Public Protector and the effectiveness of the Section 194 process while an investigation is underway. In relation to the High Court's order that the President's decision to suspend the Public Protector was tainted by bias, the DA submitted that a claim of personal bias rests on the assumption that a certain decision will benefit the decision maker. It submitted that the President would continue to be investigated by the Deputy Public Protector and would thus derive no benefit. The DA also opposed the Public Protector's application for leave to appeal against the order of the full court in the Section 18 proceedings. It agreed with the findings of the full court that the Section 18 does not apply to orders that are subject to confirmation by this court under Section 172, subsection 2 of the Constitution. The DA further argued that there was merit in the public protector's argument that the president's decision to suspend her was premature. It submitted that the president's powers to suspend the public protector in terms of Section 194(3)(a) of the Constitution was triggered on 16 March 2021 when the National Assembly referred the DA's complaint to a committee, and that the effect of the order in the Speaker judgment was to immediately alter the content of Rule 129 AD sub 3. The president's submissions were largely similar to those of the DA. He added, though, that the determination of whether there is a risk of conflict of interest in the exercise of his official duties requires that there must be a real risk that the exercise of his official responsibilities will be tainted by his private interests. He submitted that the public protector failed to show that there was a real and not hypothetical risk that his decision to suspend her would be tainted by his private interests. The public protector's main contention was that there was no valid Section 172(2)(d) application before this court. Accordingly, this court could not reach the grounds of direct appeal advanced by the president and the DA. She argued that the relevant part of the High Court's order did not relate to the conduct of the president as contemplated in Section 172(2)(a) of the Constitution, and thus required no confirmation by this court. She further argued that the part of the order declaring the president's decision unlawful was a standalone order issued in terms of Section 172(1)(b), not to deal with a constitutional order, but to address the inconsistency with the common law rule against bias. In her submission, the argument that Section 18 of the Superior Courts Act did not apply is incompatible with Section 172(2)(b) and (d) of the Constitution, and that the phrase "or other interim relief" in Section 172(2)(b) of the Constitution includes relief sought or granted in terms of Section 18, which is interim in nature and is always granted pending an application for leave to appeal. The public protector further submitted that the appealability of orders requiring confirmation by this court, as well as the susceptibility of such orders to be regulated by interim orders or interdicts pending confirmation, is sufficient proof that such orders are enforceable until set aside on appeal. The chairperson of the Section 194 committee and the Speaker of Parliament opposed the public protector's conditional cross-appeal against the first two applications, insofar as it was aimed at halting the proceedings of the Section 194 committee. They too contended that the ongoing Section 194 inquiry does not infringe Rule 89 of the National Assembly rules. They agreed with the High Court's finding that the committee will not be assessing the public protector's litigation matters concerning her removal from office, but will determine whether or not she has partaken in misconduct which would warrant her removal from office. They also disputed the alleged need to amend Rule 129 AD sub 3 of the National Assembly rules and contended that the judgment in Speaker had already cured the rule's constitutional invalidity. The opposing political parties filed submissions in this court supporting the public protector's case. They challenged the full court's findings that Section 18 of the Superior Courts Act was not triggered by the High Court's judgment, and contended that the applications brought by the DA and the President amount to an impermissible request for this court on appeal to interfere with the discretion exercised by the High Court. The political parties submitted that the order of the High Court setting aside the President's decision to suspend the public protector is a temporary decision made pending the outcome of the Section 194 inquiry. They further submitted that if the order of the High Court has no force pending confirmation by this court, then clearly the decision was temporary, falls within the ambit of Section 18 of the Superior Courts Act, and could not be suspended unless the President showed that he would suffer irreparable harm if it were suspended. In this unanimous judgment written by me, This court holds that there was a rational reason for the precautionary suspension of the public protector, which benefits her and her office, as it allows her to center her attention on her defense in the inquiry and safeguards the integrity of her office, and that it cannot be said that the president's decision to suspend her was irrational, even if there were other rational causes open to him. In coming to this conclusion, I have considered, among other factors, the report of the independent panel led by Justice Kabinde, which found that there was prima facie evidence of incompetence on the public protector's part, based on a number of repeated instances, including what it described as grossly overreaching and exceeding the bounds of her powers in terms of the Constitution by unconstitutionally trenching on Parliament's exclusive authority when she directed it to initiate a process to amend the Constitution, an incorrect interpretation of the law, failure to take relevant information into account, failure to provide affected persons with a right to be heard, an incorrect factual analysis, and a sustained lack of knowledge to carry out her duties or ability or skill to perform the duties of the public protector effectively and efficiently. The independent panel also found prima facie evidence of misconduct in the sense of an intentional or grossly negligent failure to meet the standard of behavior expected of a holder of public office in a number of instances, including the public protector's insistence on compliance with a subpoena and bullying the targets of a moot investigation, despite a court challenge having been instituted. The independent panel concluded that the charges required investigation and could, if established, lead to the removal of the public protector. I also considered the many judicial assertions made where the public protector's capacity to hold office as public protector was brought under scrutiny and was found wanting. This court itself has made gravely adverse credibility findings against him. In these circumstances, it would undoubtedly cause grave public concern about the integrity of the office of the public, sections 167, subsection 5, and section 172, subsection 2A of the Constitution. This court reiterates that the phrase "any conduct of the president" should be given a wide meaning and interpretation. As this court has said in other decisions, the purpose of these provisions is to ensure that this court controls declarations of constitutional invalidity made against the highest organs of state. There are a number of analogous judgments of this court in which it held that declarations of invalidity of a decision by the president was subject to confirmation within the ambit of section 167, subsection 5, and section 172, subsection 2A. The public protector has been unable to distinguish these judgments from the present matter. And whilst not every dispute about the conduct of the president falls within the scope of sections 167, subsection 5, and 172, subsection 2, the decision to suspend the public protector does and is subject to confirmation as contemplated in sections 167, subsection 5, and 172, subsection 2A. Regarding the argument that the president was disqualified by section 96, 2B of the Constitution from suspending the public protector by reason of a conflict of interest allegedly arising from her various investigations involving him, the official responsibility is the exercise of the power to suspend her under section 194, sub 3A, and the private interest on the public protector's submissions would be the president's desire to thwart the investigation against him. The prospect of the exercise of the power to suspend would give rise to the risk of conflict between the exercise of the power and the desire. This court reiterates that the mere risk of a conflict between official responsibilities and private interests suffices to render the president's decision unlawful, even if there is no unreasonable apprehension of bias. The risk must indeed be real, but need not materialize. It must be of such a nature that it would reasonably be be apprehended by a reasonable person, a standard lower than the reasonable standard would result in the exercise of the executive power being hamstrung, while one requiring more than the ordinary reasonableness standard from the person asserting the risk of a conflict would not be appropriate because it would unnecessarily shield the executive from the necessary public scrutiny. On the facts of this matter, this court holds that the mere fact that the public protector was investigating the president could not expose him to a risk of conflict between his official responsibilities and private interests. This is so because the power to suspend the public protector is not a power that the president can exercise without safeguards. It is a tightly constrained power which may not be exercised on a whim or for flimsy reasons. The president can only exercise this power after a committee of the National Assembly commences proceedings for her removal. The president neither determines the duration of the suspension nor decides whether there are credible allegations against the public protector. That depends on the National Assembly and its processes. His role, that is the president's role, is confined to imposing a precautionary suspension to protect the office of the public protector, which achieves nothing for his benefit because it did not delay, let alone end, the investigation against him. The acting public protector had to and did continue with the investigation. Moreover, the president has no power to choose who will replace the public protector or to influence them, as this is governed by Section 2A sub 7 of the Public Protector Act. There is no support on the record for the submission that the president suspended the public protector to influence the outcome of the Phala investigation and benefit from the delay that the suspension would cause. This court finds that the evidence does not show that the president acted in a manner which exposed him to a situation involving the risk of a conflict between his official responsibilities and private interests. As has been pointed out, the president stood to gain nothing from suspending the public protector because the acting public protector continued with the investigation diligently according to her undisputed affidavit. Secondly, the president did not suspend the public protector to prejudice her. The suspension is only a precautionary one and does no harm to her as she remains on full pay, has time to properly attend to her defense in the Section 194 inquiry, and suffers no reputational harm as she is already subject to a highly public inquiry in which the allegations leading to her suspension have been ventilated. Further, the evidence of her own bias against and unduly suspicious attitude towards the president adverted to by the High Court in its judgment militates against the possibility of a risk of conflict. Neither is there evidence to support the findings of the High Court that the decision to suspend the public protector was hurried and retaliatory, as it said. This conclusion is based on the series of events that preceded the decision of the president to suspend the public protector. On 17 March 2022, he began communicating with the public protector regarding the suspension and invited her to provide written reasons as to why he should not suspend her. Following this letter, the president granted the public protector no less than 4 extensions and undertakings not to make a decision. These facts tend to illustrate that the intention was to afford the public protector more time to make representations. The late emergence of the Phala allegations cannot taint a process which was neither hurried nor irrational. Therefore, there was no exposure on the president's part to the risk envisaged in Section 96, subsection 2B. This conclusion dispenses with the need to decide the question of bias because at the level of facts, that is whether there was a reasonable apprehension of bias, the conclusion would be the same. The appeals must accordingly be upheld and the conditional application for confirmation of the High Court orders and cross appeals dismissed. And this court finds that the Section 18 application for leave to appeal was an entirely unnecessary and anticipatory proceeding for which our court procedures make no provision. The risk that granting it would open the floodgates for similar applications is not far-fetched. It is therefore not in the interest of justice to entertain it. This finding dispenses with the need to deal with these merits, and it must fail. Regarding costs, this court holds the view that the public protector has not conducted herself in a manner that would justify mulcting her with costs in respect of the appeals and cross appeals. The nature of these proceedings warrants the application of the by-watch principle, and the court has decided not to award costs. In relation to the cost of the Section 18 application for leave to appeal, however, the public protector must pay the cost in her personal capacity, as there was no indication that the Section 18 application was authorized by the Office of the Public Protector, which had undertaken to settle her legal costs in respect of the appeals. In the result, I make the following order. The appeals by the Democratic Alliance, the DA, and the President of the Republic of South Africa in CCT 251 of 22 and CCT 252 of 22 against the orders in paragraphs 187.5 and 187.6 of the full court's judgment delivered on 9 September 2022, the Part B judgment, are upheld. 2, the conditional application for confirmation of the said orders of invalidity is dismissed. The orders, 3, the orders of the full court in paragraphs 187.5 and 187.6 of the Part B judgment are set aside and replaced with the following order. The prayers in paragraphs 3.2, 3.3, and 4 of the amended notice of motion to declare the decision to suspend the applicant issued on 9 June 2022 and the decision of the Section 194 committee to commence the Section 194 removal process to be irrational, unconstitutional, and invalid, and set aside in terms of Section 172, subsection 1F of the Constitution are dismissed. 4, the appeals by the DA and the President in CCT 251 of 22 and CCT 252 of 22 against the cost order in paragraphs 187.7 of the Part B judgment are dismissed. 5, the public protector's conditional cross appeals in CCT 251 of 22 and CCT 252 of 22 are dismissed. 6, the public protector's application for leave to appeal in CCT 299 of 22 is dismissed. 7, in CCT 251 of 22 and CCT 252 of 22, there is no order as to costs. 8, in CCT 299 of 22, the public protector shall pay the costs in her personal capacity, such costs to include the costs of 2 counsel. I hand down the judgment and court adjourns.
As the court
Thank
pleases.
you, everyone.
Thank you, Deputy Chief Justice. Today's proceedings have concluded. The host will now terminate the hearing.
Okay, goodbye.